Good afternoon and welcome to today's webinar, COVID-19 Focus on Emerging Constitutional Challenges, brought to you by the Network for Public Health Law and the American Society of Law, Medicine, and Ethics. I'm Charles Strong, the Digital Marketing Coordinator at the Network's National Office, and I'll be your host for today's webinar. A quick note that both the presentation slides and video playback for this event will be available on the Network's website shortly after the conclusion of today's webinar. We strongly encourage attendee participation and would love to hear from you, so feel free to submit your questions at any time during this webinar by using the Q&A tab on the right-hand side of your screen. All you need to do is click on that tab, select all panelists from the drop-down menu, and send us your question. We'll be addressing them during the Q&A session towards the second half of today's event. The moderator for today's webinar is Kayleen Claridge. Kayleen is the Marketing and Membership Manager here at the Network's National Office, and she'll be leading us through the rest of today's webinar. So Kayleen, over to you.
Thank you, Charles. At this time, I would like to introduce our presenter. James G. Hodge Jr. is the Director of the Network's Western Region Office and the Peter Kiewit Foundation Professor of Law and Director of the Center for Public Health Law and Policy at the Sandra Day O'Connor College of Law at Arizona State University. James, I'll turn it over to you.
Kayleen, thank you so much. Good morning, good afternoon to everyone who has joined us, depending on your location in the United States and or globally. I'm delighted to be revisiting with you all in regards to our next webinar, and today's session couldn't be hotter, couldn't be more relevant, and couldn't be more pertinent to what we're literally experiencing nationally. So to be sure, our session today is focused on constitutional issues. Now, we've been building up to this session for weeks now. The types of issues you're going to see me sort of explicate in regards to what we accomplished today are going to be honed in on the things that you're seeing and experiencing nationally across the United States in response to COVID-19. We've got a lot of topics to cover. Often I wait until the end of the session to actually thank all the different colleagues who have made such a great contributions to what I'll be discussing today, but let me start with that if I can at this moment. So without doubt, special thanks to all of our colleagues you're seeing on screen: Erica White, Michelle Nutrika, Claudia Reeves, and Catherine Farrell-Ginsbach. Both Erica, Michelle, and Claudia are all with our ASU team and have done tremendous work to get us ready with excellent research, excellent slide design you'll see shortly, and other fronts. So thank you all on behalf of everybody within our Western Region team. And Catherine Ginsbach has been a fantastic volunteer, a University of Notre Dame law grad who has actually provided some real-time guidance on some of our key issues. Thank you to all of them. Thank you to all of our Western Region attorneys, Leila Barraza, Sarah Wetter, April Shaw, who have provided great contributions to what I'll discuss today. And then most importantly, let me thank as well colleagues across the country. You know, we have been working on these constitutional issues through so many different academic fronts on so many different levels. So great colleagues of mine like Larry Gossen at Georgetown, Michelle Mello at Stanford, Wendy Carmette at Northeastern, Mark Hall at Wake Forest, additional colleagues like Scott Burris, Lance Gable. We've been working with all of these folks and getting real-time information, and special thanks to all of them. But most importantly, for everybody on the call, working through these constitutional issues, through your departments of health, through your specific entities you represent, or through any legal study you're doing as students out there or working in these issues in real time, thanks to you all for the perseverance actually trying to address everything we can do in real time. Here's our slate of what we can try to accomplish. In the very brief comments I'll give you today, probably honed in about 25 to 30 minutes at most, turning it over to Kayleen and then as well for your great questions in real time. We'll address as systematically as possible. Let's just take a real quick snapshot. We all know where we stand in regards to COVID-19, but let's just make sure we know legally where we stand, most particularly in relation to some of those core facets of those legal declarations of emergency and just how they actually reshape what we're doing. Listen, I don't know what level of constitutional parlance you've brought to this specific webinar. So one thing I'm going to do in very brief order is take just a couple of moments to make sure whether you're a constitutional scholar joined us or whether you're just somebody out there trying to figure out how these constitutional issues work in real time against the backdrop of COVID-19. I'm going to give you a primer, and it's going to be quick, it's going to be to the point, but it'll set us up perfectly for my assessment of constitutional challenges. Now listen, what I've got planned for us there is I'll give you a good sense, based on everything we've culled, with great work of all of our colleagues in the Western region and across the network, of all these constitutional issues, I'm going to give you some sort of honorable mentions, ones that caught our eye. They're critical and important, but it's our top 10 constitutional issues that I'll reveal to you shortly. Those will be discussed systematically, and those will be the ones that sort of represent a lot of what we're seeing nationally in regards to percolating issues on the constitutional side of it. Questions and comments later, of course, as mentioned as well. Oh, how did we get here in relation to this slide? I mean, this is a phenomenal situation in regards to literally every country globally having known cases, millions of cases now confirmed, hundreds of thousands of deaths. And even though we all know from an epi perspective that the mortality rate is obviously underrepresented of the numbers of cases, as well as even potentially the number of confirmed deaths, it's still calculating in at that 6% range. It's gone up in the last month, not down. And I say that because we're still working with very flexible epi data, but yet this mortality rate continues to make COVID-19 the global sensation from a pandemic perspective that we all feared back in February. The U.S. situation can't be discounted either. And unfortunately, just overnight, you saw New York and other states actually clarify some of the deaths that we probably were experiencing early on actually are COVID-related deaths. The new total death number of the United States, based on what I've seen this morning, 26,061. So unfortunately, death rates will continue to rise as we continue to experience unprecedented levels of confirmed illness in the United States as testing and other initiatives gear up. So where does that leave us? Where does that exactly find us in regards to constitutional concerns? It finds us, as per this slide, on multi-level emergencies in an unprecedented, never-before situation of literally seeing stacked on top of each other emergencies at every level of government across all levels and divisions of what we see within government. And these specific emergency declarations, be it at the international level with some influence, at the national level through President Trump's Dual Stafford Act and National Emergency Act declarations on March 13th, HHS's Public Health Emergency Declaration a month and a couple of weeks before that on January 31st, state and tribal emergency declarations, all of these change not just the legal environment through which we respond, they're making changes constitutionally as well. And I'll try to explain a little bit more of what I've got in mind in regards to that particular observation as we go forward. But the illustration of this can't be more pronounced than what you see on screen. I've produced this slide in prior webinars, but I just want you to take stock of what it's really showing. It's showing you that every state has done what we've never seen before, simultaneously declare some state of emergency all around COVID-19, all changing their legal landscape, allowing for waivers of laws and other provisions that are just profound differences that have ushered in a lot of different types of legal approaches that now, you see, as we're weeks into it, have started to lead to the types of constitutional challenges we could have predicted weeks ago, but they've surfaced. And they've surfaced because of the phenomenal things that you're seeing states capable of doing through governors, through state departments of health across the country. So this sort of phenomenon is what and how we actually balance these concerns. I like to call it legal triage because this is happening in real time. I mean, we're working systematically to actually build a favorable legal environment that does a good thing of prioritizing issues and find solutions that facilitate legitimate public health responses. Somewhere along the way, of course, constitutional tripping points are occurring. And we're reaching those issues as we speak. We're reaching them on a lot of different concerns. For example, all of these emerging legal issues, some of which have been the source of the particular focus in prior webinars, are tripping constitutional points. And that's a neat way of basically saying constitutional concerns are arising from our real-time emergency use of all of these specific powers available to governors, available to the president, raising constitutional concerns. Some of the most dynamic of these issues clearly relate to social distancing powers. You're going to see these referred to in very key order in just a few moments. And we've obviously done some great webinar work together in the past on focusing just on these powers, but they trip a lot of the constitutional wires as well. So let's turn our attention to when we speak about constitutional concerns, no matter what level of expertise you bring into this discussion, I really just want to make sure we start with core first principles let's take that 2-minute constitutional primer and make sure when we talk about constitutional balancing and the structural and rights-based issues that are at stake here, that are playing out nationally across all the litigation that we'll see here in just a moment, let's take a quick look at just exactly what I mean. When I'm teaching constitutional law with our fantastic students at ASU Law, I love to use this sort of pyramid scheme. And what the pyramid scheme, with apologies for a little bit of formatting issues here from what you're seeing on screen, what this pyramid scheme does is it just basically demonstrates what we spend inordinate amounts of time in law school and, of course, in practice trying to explain constitutionally. The Constitution does 3 key things. It divides government power. That's federalism between federal and state and local type of entities. So that's you're seeing at the federal level through President Trump's powers as contrasted with state governors' powers. That's federalism at work. It separates government branches. That's separation of powers, obviously, the legislative, executive, and judicial. And then the Constitution also does that very unique thing. It protects individual rights from governmental interference. And at the bottom of the pyramid, what you're clearly seeing is an illustration of all these different types of rights. There's more than what I've depicted here, but these are ones that are starting to get considerable constitutional attention. Take, for example, this sort of series of icons of how to think through these constitutional concerns. So what you're actually seeing here is an array of constitutional issues, each with a neat little icon to somewhat remind us of what and how these issues are getting, basically attended to in regards to some of the litigation. Try to remember some of these icons because they're going to come back up as I get to my top 10. But what you're seeing across the screen can't be or must be emphasized to some degree. The powers you're seeing at the top, the structural constitutional norms, separation of powers, federalism, supremacy-related issues, preemption concerns, judicial deference. These are the structural norms that you see built within the Constitution. Again, there are others, but these are the ones we're going to hone in on today. And everything you're seeing in the red language below, freedom of expression, freedom of assembly protected by the First Amendment, freedom of religion pursuant to Free Exercise Clause, again, the First Amendment, the substantive and procedural due process concerns, privacy rights that have been implicated through Fourth Amendment, Fifth Amendment, Ninth Amendment, 14th. These are all significant, as well as equal protection, rights to travel. The right to bear arms comes in under the Second Amendment, clearly, as we'll see. Cruel and unusual punishment protected against in regards to Eighth Amendment concerns, and takings pursuant to Fifth Amendment or 14th Amendment. What's important about this slide, if you're not as familiar with constitutional law, is you can look at a single icon, like right to privacy, the door icon there, and say, well, that's what we're going to hone in on, and we will take a good assessment of how that works. The dilemma is that to understand fully what's going on with some of these constitutional issues, you have to know that these are not distinct icons. They are actually highly correlated and highly related. And what I like to call constitutional cohesion, what so many constitutional scholars, but also the U.S. Supreme Court consistently recognizes is that those sort of structural principles I was talking about, federalism, separation of powers, and those individual rights, right to privacy, right to free speech, these are highly interrelated. They regularly cross paths. They're all designed to do the same thing within the Constitution, and that is eliminate to the fullest degree possible the potential for government vices to interfere with how we actually go about as democratic society. This sort of recognition of cohesion does raise the ramp of what and how to think through constitutional issues in real time. And it gets fun fast in regards to exactly how these things get balanced in regards to real-time constitutional issues that we'll discuss here in just a moment. Should you think for a second, however, that we're actually crafting this sort of cohesion idea from something very new in what we're seeing in constitutional parlance? No, we're not. Take you back to 1905 Jacobson versus Massachusetts, a case that will come up later in our assessment here in just a few moments. And that's exactly what the U.S. Supreme Court, under Justice Harlan and his majority opinion, still very good law, basically allowing for mandatory vaccinations of adults in response to a smallpox outbreak in Massachusetts. This is what the court did. It literally used and assessed individual rights arguments raised by Jacobson to assess and counter structural limitations that Commonwealth of Massachusetts was raising. It's a neat way of saying that what was happening in 1905 is the court engaged in an assessment of cohesion, structural issues implicating rights-based limitations. That observation is going to come forth here in just a second. you want to take it to the next level, we can talk about how far you can go with those observations towards recognition of actual potential rights to public health that might be federally embedded if you really want to look deeply into the Constitution. And that's another webinar on another day, and as a topic could be quite interesting for us to explore, as we've done in this article in the University of Michigan Journal of Law Reform with several great students that I've worked with. What's important, however, is not that we digest whether there's a right to public health now. It's that we understand that that specific point about the flexibility and the capacity of the Constitution to flex in real time, to be responsive to the issues around it based on interpretations within the realm of what judiciary may do in response to these specific issues, that's for real, because we are literally engaged in a constitutional recalibration as we speak. How we balance individual interests as contrasted with communal interests in a real-time, sensational, unprecedented national emergency is really what's at stake. And how we actually do that and what guidance we receive from the court, whether we're going to actually provide and use this traditional sort of constitutional levels of scrutiny, the balancing tests that we've often been tied to through the U.S. Supreme Court and other jurisprudence. You know, you're just seeing examples of those tests here related to equal protection issues, substantive due process concerns, whether and when we'll actually utilize these types of levels of scrutiny in a real-time event like now. That's what we're out to assess. What and how far may we go with it? Okay, enough of the theory. You have a good sense of, at least constitutionally, how we might be thinking these things through. Let me take you now into exactly what we've seen in regards to the constitutional challenges. There have been, unquestionably, a chorus of claims that have started to arise. We predicted these from weeks ago. They're showing up in the media based on litigation that's happening across the country. So literally, as Americans continue to experience what we've seen done on social distancing, on shelter in place, on stay-home orders, on right to travel related issues, you know, they're starting to resist in a way that's showing up in litigation. And these specific headlines you could see in any newspaper or any major media anywhere across the country. These are just exemplary in that respect. Now, from this, we've been calling a lot of observations. And let me, if I may, just share with you what we've kind of seen as really neat honorable mentions. These didn't make our cut for top 10, but they are very neat constitutional issues. So we've seen, for example, various different interpretations of home rule limitations in South Carolina through the governor there. We've seen orders from legislators in Idaho being seriously questioned. Representatives of the Idaho State Legislature almost telling the body politic there seriously question the legitimacy of stay-home orders. We've seen Kentucky go the route of actually angling recalcitrants, people unwilling to participate with quarantine or isolation initiatives, literally being angled to keep track of them in the particular jurisdiction. We've seen issues related to the rights of the accused in Texas being raised, even issues regards to whether and when churches should be receiving federal or state COVID funds being challenged. The habeas corpus provisions for juveniles housed in New York have been a very sensational issue we'll address as well, but more so with prisoners. Challenging beach closings in Florida, obviously, what you saw there in March was just one of those pre-stay-home order initiatives that was sensational. And even rights to assemble in New Hampshire challenged the governor there for the purposes of exactly what and how far he can go in issuing those sort of limitations. There's so many more issues that could have made our honorable mentions. Let me tell you about the top 10. These are the issues that, at least based on our observations, are percolating nationally. They're representative of what we're seeing in regards to the constitutional concerns across the country. So we're going to take a wide swath across the United States and pull from specific jurisdictions observations related to, for example, national versus state powers in D.C. We'll see that in just a second. Religious congregations in Florida, crisis standard of care concerns in Alabama, working across the United States, reproductive rights. We will end our discussion with that in Texas, and will that be a dynamic issue? Airport assessments right here in Phoenix, Arizona, gun shop closures in California, quarantine and isolation concerns arising in Seattle, King County, Washington, prisoners and how we actually address their specific needs in Chicago. We'll look at takings concerns in Pennsylvania and work our way across to travel limits in Rhode Island. We'll wrap up with that. Now, each of these brief little illustrations, what I hope to be able to do with is just kind of drill down very quickly to the core legal concerns. Remember those icons I showed you. I'm going to use those at the bottom of the screen to give you a good sense of the types of constitutional issues that might have been tripped up by some of these concerns. So let's start with a quick assessment, getting right to your questions and comments as soon as possible based on what you've seen emerge just this week. So this is just one of those moments in time where you have to imagine, are we at that threshold where we could see something so sensational done in relation to the battle over power that would lead to potential reshaping or reassessment from a balancing or structural initiative of exactly who's in charge from a federal or state perspective? Yeah, we really can. Because what you saw President Trump do on Monday, basically issuing in a tweet and then backing it up with some very formal comments in his White House press conferences, is literally say the president essentially is in charge of when we're going to reopen the country. I mean, the unabashed language of what President Trump said in his tweets and later in his formal messaging through media and other fronts, though he has backed off of some of that today after some extremely strong resistance from governors both on the West Coast, out here in the West Coast with California taking the lead on some of those observations, and East Coast, an alignment of multiple states, including New York and Massachusetts, resounding concerns here too. This is the federalism and supremacy debate, as you're seeing at the bottom of your screen, literally enveloping rights to travel and other concerns about when and who, under what circumstances, in charge of reopening the United States in response to COVID-19. This is sensational. It's going to very likely lead to immediate judicial intervention, I dare say, at the very near future. And what we have to consistently balance here from a federalist perspective is just remember and recognize exactly what's at stake with these types of observations. Who actually is in charge and of what specific powers? Media's been all over it, as we know, for the last, basically 48 hours. This is going to take judicial intervention to actually ascertain. Should it get to the U.S. Supreme Court very fully? Here's bold predictions in relation to that court's assessment. This is a pro-federalism court. This is a court that has consistently respected state rights, not just most immediately, but over the last 30 years. And in a sort of new federalism way, the court has consistently shown a disdain for anything that might be viewed as a federal invasion against core state functions, any effort to actually commandeer states into what they will or won't do in response to a lot of things, very likely including major public health emergencies, and a recalibration of exactly what powers are given to states versus feds based on this type of observation, stemming solely from power struggles that you're seeing politically. This is sensational stuff. Predicting the bold outcome of this will be very difficult, but it's going to take a lot of interest in regards to, or it's going to absorb a lot of interest in regards to how governors at whatever level fall in line or reject what President Trump may be saying in regards to guidance forthcoming. Let's head back west. I'm right here in Phoenix, Arizona, and what you see here in what Governor Doug Ducey has done recently on April 7th is being resonated across the United States and so many other jurisdictions. All of these most immediate concerns related to when and who and how we're going to isolate or quarantine among persons entering specific jurisdictions. You're seeing these issues crop up nationally. What Governor Ducey did is basically said in an executive order pursuant to his public health emergency declaratory powers, hey, we're actually going to authorize immediate self-quarantine or isolation for travelers that arrive at Arizona airports, including Phoenix Sky Harbor, from areas with substantial community transmission. I mean, it sounds appropriate. It sounds like a good public health social distancing measure, but then he spells out quite precisely that most specifically includes persons coming from New York, Connecticut, and New Jersey, and that will be done in coordination with airport authorities. Now, the tripping points here are very clear. First of all, whether or not from a pure federalism perspective, a governor can actually dictate the types of persons coming in interstate to an airport and then being subjected to specific travel and or other concerns raises immediate issues. We're going to see some of that percolate in any number of different cases that are already starting to surface. But the pure equal protection issues here can't be discounted. What sustains actually segregating persons from 3 states, New York, Connecticut, and New Jersey, notwithstanding profound array of disease within some of those jurisdictions, but what, from an equal protection analysis, allows that type of coordination or sort of segregation to occur? It's highly problematic. It lacks some level of rationality. It person coming from Connecticut may have had zero exposure to COVID, just the same as the person coming from Wyoming. To set out that criteria within these orders is tripping constitutional concerns over equal protection. And yet the additional concerns you see in regards to other orders of this nature are already surfacing in places like Rhode Island. So in Rhode Island, you saw this very interesting dynamic of a governor clearly concerned about the sensational number of cases in New York City and New York State in relation to COVID-19. And so she issues an executive order on March 26th, basically requiring self-quarantine for travelers solely coming from New York. Made it quite clear, if you're coming from New York, and we see that on your license plate as you enter, as per inspection or such, we're going to have to issue some level of restriction about you coming in, or isolation or quarantine related to that. Now, Governor Cuomo in New York did threaten to file suit 2 days later, and she subsequently dropped the New York-specific initiative, but applied it to all travelers. That could be coming to what we see in Arizona soon, too. The right to travel repercussions are there, but I'm most interested as well in what you're seeing in the middle issue, specifically right to privacy. Most particularly, what level of search are we talking about being done here in relation to this specific initiative? So as you enter across a border from Rhode Island, or into Rhode Island from New York with your specific license plate or such, is that the type of thing that would sustain a legitimate search and seizure of persons for the purposes of assessing the public health ramifications of allowing those persons to cross into state borders? It's highly problematic. And the Supreme Court just recently, in Kansas versus Garvey, just last week, made it quite clear that the ways in which you can actually conduct searches based on the typical initiatives of how you actually think through what constitutes a reasonable search and seizure. It is about reasonableness, but whether a person coming solely from New York with tags actually presents any risk to your population, that was highly problematic. And whether or not that would sustain anything along the lines of a lawful search for the purposes of assessing a real public health risk, major repercussions. Now, the governor's backed off of that, but again, these sort of stop and check type of initiatives that are being done at some state borders, highly problematic, and largely because of some of these concerns constitutionally. What you're seeing in Seattle and King County is really interesting. Now, listen, they've made some fantastic adjustments and done so well to actually use social distancing to a high level and actually tap down quite significantly on COVID cases in that jurisdiction. But what you're actually seeing there done most recently raises some interesting additional concerns, because what you're seeing in Seattle and King County is a single order issued within that jurisdiction, basically saying that any person testing positive for COVID-19 must self-isolate. That's, understandable. And persons that actually present with COVID-19 symptoms must self-quarantine as they await for their COVID test. So you have symptoms and you're seeking a test. We need you, pursuant to an order like this, to actually go ahead and self-quarantine at this juncture. And it does make quite clear in the order, non-compliers could face involuntary detention. This sounds like appropriate social distancing. We use quarantine and isolation powers quite extensively, and to be sure, this looks legit, but the problem may rise in relation to due process and how much deference we're going to give, pursuant to a judiciary, to an order like this that doesn't specify particular persons that would be subjected to it. So this is a neat illustration. When you're doing quarantine and isolation without question in regards to constitutional repercussions, you're doing it in a way where you have actually specified that a particular person or a particular group of persons does raise real risks, that we have very good information with high level of suspicion or confirmation that a person may have been exposed to COVID or may be infected. When you do that, you can quarantine or isolate in the United States, as we've seen consistently, without constitutional concern. But when you issue a general order that taps nothing more than the sheer fact that a person may have symptoms and then seeks a test, does that sustain a constitutionally valid order? It lacks the type of procedural due process we typically would see. It's a blanket order that applies to anybody in Seattle, King County. And while it may have, from a social distancing perspective, some very real impetus for controlling for infection, it does raise very interesting concerns about how much due process still might be needed to effectuate a quarantine expectation that could actually result in involuntary detention, where a person simply may not actually pose any risk simply because they have a symptom and got a COVID test. They may not have COVID, and their symptom may be unrelated to it. It's an interesting issue, but one of which hopefully will be successfully worked through in regards to Seattle should it come up in actual litigation. What you're seeing in relation to religious congregations, not just in Florida, but in so many states, post the holiday weekend with Passover, Easter, and other holidays coming together, has really taken dominated a lot of what we see in media attention. Now, the issues here are really profound, and this example out of Florida, basically in the Tampa area in Hillsborough County, basically essentially issuing misdemeanor charges against one reverend there, actually convened 2 large church services, only later to see, within days, Governor Ron DeSantis issuing his executive order, imposing stay-at-home orders, as we see in so many jurisdictions, but exempting religious services. What and when and how do these types of provisions actually implicate rights to assemble, actually implicate various different freedom of religion, free exercise issues, and or what's the legitimate use of preemption here for a state to preempt, here in this case, Florida, Pillsbury County's objective to actually not exempt persons in religious-related settings from these specific measures. Let's just take those on real quick and be understanding about timing, but also conscientious of just giving what we probably could predict to be a constitutionally valid test for rights to assemble. First of all, you've got full rights to assemble under the First Amendment, but they have absolutely been curbed and or balanced always against any risks to the public's health. You don't need a pandemic like COVID to remind us that your right to assemble have always been balanced consistently with various different public health interests. And we will balance those, as we've seen in multiple Supreme Court jurisprudence, against the public health interests. In other words, your right to assemble can be curbed to a degree. Free exercise of religion always raises very difficult, significant concerns under the First Amendment as well, because of the really profound sort of free exercise provisions that we're all entitled to under the First Amendment. But even those, the court has made very clear, do not run rampant. They're not absolute. They can be curbed and balanced against the actual sort of general measures that might be issued when there's compelling state interest involved to actually limit the spread of disease or otherwise. So just a very neat observation here on free exercise. You've got it, but you also, from a First Amendment perspective, can have that free exercise limited, obviously in relation to things that might apply generally in regards to COVID-19 related responses. It's a neat way of saying on this specific slide, I see a lot of these issues coming up via litigation, and I see many of them being resolved at least judicially by recognition that free exercise is not absolute and definitely stops at the door of where and how it may impose specific interests or specific concerns from a public health perspective. These gun shop related closures that you're seeing in California and multiple other jurisdictions are being severely challenged by the National Rifle Association and a lot of other enterprises, basically assessing whether or not we can close gun stores during the course of these emergency events, particularly because of the difference between the shelter-in-place and stay-home orders, some of which view in jurisdictions gun shops as essential businesses, some of which don't. Now, Governor Newsom in California made no clear distinction about that, but Sherriff in LA said initially that he saw retail gun shops as non-essential and then closed, required them to be closed. That was later rescinded, but yet LA, the city now, has actually viewed them very similarly. These are not the types of retail enterprises that have to remain open for the purposes of the governor's order, and you're seeing considerable litigation in California and in other places around it. On April 6th, we saw the U.S. District Court actually deny that request for a temporary restraining order against the executive order through Governor Newsom. And the ways in which you might see this balance in the future, they do implicate Second Amendment rights. They clearly have procedural due process concerns involved in federalism concerns as well. But the U.S. Supreme Court in Heller, in D.C. versus Heller, that is, in 2008, which later applied the same sort of Second Amendment expectations and rights to cities and states, the McDonald versus City of Chicago, they clarify quite nicely in those opinions. Hey, government, pursuant to Second Amendment rights, can still set conditions and qualifications on the commercial sale of firearms. That's what and how you might see these provisions being interpreted by courts that are actually assessing these in real time, whether or not they pose legitimate and reasonable conditions for a limited temporary sale is what's at stake. And mind you, we will see just exactly how these cases come down in different jurisdictions, but that's what the Supreme Court has really given guidance on, may play out here well. takings in Pennsylvania. These cases are neat. You're starting to see governors get very concerned. I've heard through some other enterprises about these types of takings decisions. And so being brief here now to get the last couple of entries, because we've got just a couple more in regards to our top 10. This is interesting, what and how you've seen this case arrive in Pennsylvania. So we've been under Governor Wolf's central business closure issue since March 19th, and we've seen specific enterprises, particularly this one company, Schulmerich Bells, which is, I think, the largest bell manufacturer in the world, actually issued a class action lawsuit alleging this is a forced business closure. We've lost revenue, we've lost wages, we've lost employees. This is a taking, says the bell company. This is a taking of private property without compensation in violation of the Fifth Amendment. They also raise procedural and substantive due process concerns too. It's an interesting decision. Why? Or not decision yet. We don't have anything out of the court yet, but it's an interesting claim. Why? Because if what we're doing in regards to shelter in place, closing businesses, staying at home, if this could constitute a taking, this will be significant in regards to ultimate payouts and other concerns. Constitutional parlance or constitutional issues on this fully suggest if you take property, private or personal, personal or real property, you must compensate for that later and after the fact. Supreme Court's been quite clear on that too. But there's two critical differences here. You have the type of taking that can involve a literally physical taking, where you just strip somebody completely of all use of their property. That's clearly a taking here, or that's clearly a taking that requires just compensation. And then there's very likely what we're seeing here raised, a regulatory taking, a temporary potential taking of viable use of property for a legitimate public health concern, whether or not that would be viewed by the U.S. Supreme Court or other courts as a taking sufficient to garner just compensation. You know, governors shudder fear over this because they're very concerned about whether that could arise. I don't see it happening solely because the basis on which you're seeing these specific temporary interventions being done is a very compelling governmental interest in actually, limiting the spread of COVID-19. And you literally have to see under Supreme Court jurisprudence almost just a complete and total taking of all proprietary interest in a specific enterprise before you could actually adjust a regulatory taking. We shall see, but I think these cases may resolve in those specific points as well. Prisons in Illinois, what you're seeing in regards to how we actually are addressing COVID-19 in prisons and other juvenile facilities, as I mentioned earlier in some of our sort of honorable mentions, is a profound Eighth Amendment concerns. These raise substantive and procedural due process issues as well. The class action lawsuit filed against Governor Pritzker and the Department of Corrections in Illinois, largely because of multiple prisons in Chicago, have raised very interesting issues as to when and how the failure of prison systems to appropriately address the risks of COVID-19 to the prison populations, does that result in an actual violation of the Eighth Amendment? Is it cruel and unusual punishment to have prisoners in a setting, as you see in multiple different arenas, federal or state or even local prisons, of which COVID-19 can spread systematically, as it has done in several different prisons, leading to potential harms to the prisoners in and of themselves? The standard here that the court consistently has turned back to in Estelle versus Gamble in 1976 and consistently used about when and where the Eighth Amendment's trip is really that sort of assessment of when and how alleged acts or admissions might be sufficiently harmful to evidence a sort of deliberate indifference to serious medical needs. So it's only when such indifference that could offend what we basically review as sort of almost evolving standards of decency that the courts made quite clear, that's when you have a violation of the Eighth Amendment. I think it's fair to say, especially acknowledging so many governors and others making favorable policies that actually are working hard to try to eliminate the risk to prisoners as much as possible, a complete abject failure to address COVID-19 in prison systems, that's going to trip Eighth Amendment concerns big time. But against that backdrop, prisons can only go so far in relation to how they can accommodate these interests. And that balance is at work as we speak. It's a tough balance. It's one that's going to be resolved in real time, and we'll see multiple cases, but interesting one for sure as well. Crisis standard of care concerns are dominant nationally for so many good reasons. We're implementing these in a lot of jurisdictions. These are raising significant and profound concerns. as you see, for example, in Alabama. Now, listen, they've had an existing emergency operations plan in that state for EOP for years. And that emergency plan, actually for years, listed multiple health conditions specifying severe mental retardation, dementia, and severe traumatic brain injury as those types of conditions for which we would then, not automatically, but then be able to use for denying specific crisis type of interventions for persons with those conditions. Now, to the degree to which that sat dormant and kind of gathering dust in Alabama for a few years within their crisis standard of care plan, that still was challenged, but when it started to surface as whether or not it would be applied in COVID-19 related events, that got before the HHS Office of Civil Rights. They reviewed it systematically and negatively for the purposes of literally issuing back to Alabama a sort of cease and desist order, which Alabama has formally rescinded that guideline. Case closed in relation to that, quite possibly, but the reality is simple. You're dealing with equal protection, substantive due process, and even separation of powers related concerns about how much federal oversight of these state-based crisis standard of care plans may arise systematically. The equal protection facet is truly unbelievable. It literally provides under equal protection, you've got to treat similarly situated persons alike. You've got to do it, and there's nothing about that that gets waived in an emergency. Rebalance, quite possibly, yes. But the crisis standard of care side of it really does raise profound facets for so many reasons. I mean, the types of persons that may benefit most in implementing crisis standard of care may be persons who lack these specific disabilities, or may be persons who actually are, more favorable to survive. And these provisions of how we actually build that into crisis standard of care plans becomes systematically interesting from an equal protection point of view as well. Now we're seeing real evidence emerge that quite possibly African Americans are suffering greater rates of harm from COVID, including death rates, in regards to the specific conditions for a litany of related reasons, but when and how we actually could then embed sort of a assessment of whatever other types of racial or ethnic type of interventions may come into play, really problematic, so sensitive, so difficult, going to continue to result in a lot of litigation as we speak. Let's take our last case. Let's be brief and get right to your questions. If there was an icon for a kitchen sink, I would have put it in here. It literally, this case, trips every single one of these interventions. Let's be brief about it, just so we're really clear about what's going on, not just in Texas, but in Oklahoma, Ohio, and other states as well. So you've got these executive orders that have done everything we can through governors to try to move resources into crisis standard of care, and most specifically into treating COVID patients. You've seen a lot of governors actually say, let's just cancel certain elective procedures or certain even semi-required procedures because we need to put every resource possible, including protective equipment and personnel and beds, into COVID-19 response efforts. Some jurisdictions, as you saw in Texas, when Attorney General Ken Paxton actually interpreted that language to say, okay, no surgical abortions. Now, under these specific orders for that duration, and then Texas, I think it goes through April 21st, we're not going to allow surgical abortions in Texas unless there's the life and the health of the mother is directly impacted, or maybe a few other certain limited circumstances. Now, you can imagine just exactly the type of litigation that's arisen around this. The right to privacy concerns, the equal protection issues, the substantive due process, separation of powers, the federalism concerns, all of these things have cropped up, as you saw in the Fifth Circuit Court of Appeals decision that came down very recently on April 7th, in which the Fifth Circuit out of New Orleans makes quite clear, at least under their analysis, Texas can do this and is doing it lawfully. And the basis for which they make that determination is unbelievable, that they utilize Jacobson versus Massachusetts, the case we originally honed in on as far as that cohesion provision, to denote just how much and how significantly we can inhibit specific constitutional rights, even to rights to abortion as interpreted by the Supreme Court previously during these emergency events. Now, this will be sensational in regards to when it reaches the U.S. Supreme Court, which it has in regards to the courts agreeing to hear the case. You got a contrary decision out of the Sixth Circuit in Cincinnati, Ohio. These are profound issues. Literally every icon at the bottom of your screen implicated in these types of decisions. Bold and tough to predict as to how the outcome will occur. We'll see what questions and comments arise as well. All right, I apologize for being a little bit long-winded with that. Let's take all questions and comments we can. And to that end, Kayleen, please go right ahead.
Thank you, James. We'll go straight to the Q&A. I take your point that Trump's assertion of executive power may end up in court. But do you really think this is an open legal question? Or would you agree that precedent overwhelmingly supports the view that the president is mistaken?
Wow, that is such a neat point, and I love that question. So well stated, and let's be quite clear about this. Yes, the president is mistaken. This power does not exist at the national level to tell state governors, vested with their sufficient police powers, executing them pursuant to 10th Amendment reservations, pursuant to federalism concerns. There is no legitimate way in which the president can dictate to governors who will open when, and under what circumstances, when you fully assess the gamut of what's been assigned under our sort of core assessments of federalism. Now, let's be sure of this. These are very dicey times. This is going to result in very likely Supreme Court jurisprudence, I think, at some point or another. Even if the issue is moot in 30 days or so, this is going to be something in the second wave of COVID that could be revisited. So to be sure, what and how the president's made clear statements about the sort of total absolute authority they have to tell states to reopen, not likely, not possible. There's literally no route other than through something that, I don't think you'd see the president go in regards to sort of declaring this a national security threat, overtaking what you might see states' capacity to do. But even that's highly questionable. The best analysis you can do here is to basically say, I think even President Trump now realizes he may have overstated that ever so slightly. We're in a negotiated, cooperative federalism infrastructure. This can be done as far as reopening the United States safely, and it can be done legally. But it starts with federalism, and it works through cooperative arrangements. Aileen, thank you. Go ahead.
Do businesses that accept stimulus funds have to release any takings claims that they may otherwise be able to assert, even if they might not win?
Oh, that's interesting. So when you're getting these specific funds and you're actually, potentially receiving some of the resources of the federal government through the very significant stimulus bill, the $2 trillion bill, with potentially more coming along the way, would that alone actually implicate, or at least suggest, you can't call it a taking if you're actually receiving resources back? No, actually, I don't think so. That's what's neat about it, is that the taking provision here, even if government is doling out specific resources to help mitigate the potential impacts, the U.S. Supreme Court has been quite clear that actually there may still be a constituted taking. There's a specific case I'm referring to here. It's actually Horn versus Department of Agriculture, a case in 2015 in which the U.S. Supreme Court involving crops set aside for raisins in California and such. Literally government is going to pay for certain crops to not be produced in regards to it, and the sort of assessment of that payment was one of which the court was assessing very completely whether or not a taking could actually occur because government was paying for those specific crop set-asides. Chief Justice Roberts makes it quite clear in the case. It can still be a taking. We're still literally taking the crops. Whether just compensation meets that or not is subject to debate. But I would be this in regards to those payouts forthcoming through various different stimulus bills and otherwise. Aileen, go ahead.
Please explain more about the intersection between First Amendment rights and mandatory shelter in place or social distancing orders. In North Carolina, police recently arrested protesters outside of the North Carolina General Assembly for violating executive orders from Governor Cooper regarding mandatory 6-foot social distancing and associated shelter-in-place provisions.
Oh, that's great stuff, and I'm starting to see this not just in North Carolina, but if you're sort of scoping out what you're seeing nationally, you're seeing resistance begin in some ways. Small for now, but as Americans' patience wears thin on some of these stay-home and shelter-in-place orders, you might projectively see more of this in the very near future. But the question really raises the issue. Is that the type of how do we actually balance rights to assemble, particularly when you're assembling for political speech to object to what government's actually done in response to COVID-19? There is no speech more protected by the U.S. Supreme Court than political views and speech. And yet you saw in North Carolina I think it was yesterday or maybe on Monday, literally police forces, disassemble that crowd and actually arrested a few people in relation to it. What and how do you balance that? It all falls back on exactly the same thing I was discussing earlier. Rights to assemble. Even with the assembly over political speech at the highest level of First Amendment protection, if those rights then effectuated pose real risk to the public's health, those rights can succumb to that from a constitutional balancing perspective. You know, think in a COVID-19 situation where the government's interest is so greatly compelling, even when you're seeing political speech done on literally the steps of the state capitol in North Carolina or otherwise, government and or law enforcement is well positioned, at least to suggest we still have strong enough interest that we're going to limit those rights to assemble under those circumstances. They can't cut off all rights to free speech. They can't suggest we don't want to receive your message at all. Please do not voice any of these concerns. Just open up additional channels of communication and your First Amendment rights can be respected to a full degree possible without implicating the public's health involved. Great question, Kayleen. What else you got for us?
Regarding the Texas abortion case, the rationale is drain on COVID resources, a factual question. Kennedy's opinion in the so-called partial birth abortion cases indicated that legislative determination of fact will control, even in the face of contrary medical opinion on a medical question. So for the Texas case, is it doctors or the governor whose assessment of how much abortion uses supplies will be controlling?
Right, neat point. And I love that observation about Justice Kennedy's prior assessments and specific jurisprudence at the Supreme Court level. Well, at least at the Fifth Circuit out of New Orleans in that contested 2-1 decision, you actually saw the Fifth Circuit give considerable credence to what the sort of executive agencies are suggesting is needed. It actually chastised the lower federal district court badly. I mean, really took them to task, saying that the lower federal court in Texas that was originally reviewing the case was attempting to substitute its own judgment over the executive agencies. Something even in Jacobson versus Massachusetts, the Supreme Court said, that's a don't do. That's a federalism and or separation of powers concern when a federal court's reassessing or reinterpreting its judgment for what a state executive agency is attempting to do. But you're seeing also contrary opinions as well. And so other opinions at the federal district court in Texas, I haven't fully seen the Sixth Circuit's assessment of this, but we'll look into it further as well, are going to raise the concern about just how much scientific and other evidence should come into play and be allowed. Now, a quick update in the Fifth Circuit is important to note, and we'll continue with additional questions because I don't have this data for us now, but glad to look into it. Whoever asked it, please raise it with me separately via email. And that's this observation. The Fifth Circuit remanded it back to the lower district court and knew there was going to be a subsequent hearing to fully assess the potential for whether or not what Texas had entered in regards to its specific order presented an undue burden on the constitutional right to abortion. They were going to receive considerable evidence, and the ways in which that federal district court in Texas may have worked through some of that additional analysis, I have not yet seen. But that was literally on Monday, so we shall get a better sense of exactly what evidence and exactly who was receiving it would be, for the purposes of judicial deference, entered into this specific equation. Neat point. Thank you for raising it. What else you got for us, Caitlin?
We have seen several clashes between mayors and governors across the country. What constitutional issues are playing out in these conflicts?
That's such a great point. And one of the honorable mentions that I actually mentioned earlier was one of which I could easily have up on screen for us as far as one of our top 10. Was right at the top of this illustration that you're seeing here on slide 25, the home rule limitations in South Carolina. This is the dynamic and sort of drama playing out across state and localities all across the country on all these specific initiatives. How much home rule should we be given to our larger cities to respond to what and how they feel is necessary as contrasted with state preemption? This is a dominant concern because while preemption at the federal level still has to meet a lot of the federalism sort of concerns, it's not true at the state to local level. States do dictate to local governments what will and what will not be done pursuant to the preemption model that we see at the state level. I mean, local governments owe their existence to the state, and they have to succumb to some of those interpretations. There are constitutional challenges back to that, whether we have seen successful outside of the emergencies. But what was playing out in South Carolina is amazing, is how the governor there was actually, Governor McMaster, issued to cities the size of Columbia and Charleston, very clear orders. You don't engage and do not issue stay-home orders. That is contrary to state policy, and we're not going to allow you to do it. Only later, I mean, just days later, the governor did go ahead and issue a modified stay-home order for all of South Carolina against the backdrop of what you're seeing and the risk to every population across the state. What's important is the drama playing out on this state to local sort of dynamic is dictating consistently what and how locals can respond. This is happening in Florida, it's happening in Texas, it's happening in California, and those debates are ones which are so real time in relation to the scope and effect of preemption and the political accountability for governors and others basically issuing these specific fronts that we literally have to assess them almost in real time as well. The neat point, though, that just how much of this comes into play and how it can dictate what local governments can do directly. So, Kayleen, what else do you have for us?
Do you anticipate that states will mandate a COVID vaccine for some individuals?
Wow, will they mandate it for some individuals? Let's be really clear in regards to the vaccine situation as what the difference is between a mandatory and a compulsory vaccine. Mandatory from a constitutional perspective is literally saying to persons, we highly recommend you get the COVID vaccine if and when it's produced and safe and nationally available. We highly recommend you get it. And if you don't get it, we're going to set some conditions upon its receipt that maybe you don't get to participate in these specific functions in society or otherwise. Those will be contested and they will be problematic because you can imagine certain vulnerable populations or certain persons of lower socioeconomic status literally not getting access to vaccine at the point in time that we would most want to see that. Mandatory vaccination requirements, setting conditions on receipt of the vaccination, very likely could survive some level of constitutional scrutiny. We do use these consistently, for example, in the school vaccination arena across the United States. Compulsory vaccine is not playing around, though. Compulsory vaccine is literally saying, you're going to get it. We're physically going to make sure you get it. We might be able to compulsorily vaccinate prisoners. We might be able to compulsorily vaccinate juveniles who may be in detention facilities for their own interests and as wards of the state. But autonomous adults that don't want to undergo a vaccination for COVID-19, notwithstanding whatever benefits come from it, the idea that we may have something like a mandatory/compulsory vaccine would run a front up against various different Fourth Amendment and other specific rights to privacy and other liberty interests that would be just compelling. We shall see how that plays out. But right now, I would not predict it just based on what and how we've seen Constitution that layout. Holly, maybe time for one or two more questions?
Okay. A law office in California is sending letters to counties that have mandated masks, threatening a federal lawsuit, and stating that the mandate violates the Equal Protection Clause, essentially stating that it has a disproportionate impact on the poor or those that cannot wear a mask for medical or other reasons. Do you think this argument has teeth?
That's an interesting one. Now, I thought this would start to arise too in relation to who has access to that simple intervention. And though these masks might be able to be made at home and or survive specific assessments of what a particular state like California is looking to accomplish, the idea of access to it, this is very interesting to how it may impact specific vulnerable populations like persons without shelter or persons lacking homes or whatnot. This sort of observation and assessment of that is a really interesting one. But to be sure, when we're talking about the capacity for a simple mask to actually greatly limit, to the degree it can, spread of COVID within specific public settings, I think those specific requirements in California will hold up and will withstand any scrutiny, even against the backdrop of the equal protection concern. It would certainly help a lot, as you saw, in some of the sensational video accounts in Philadelphia, the person being pulled off buses by law enforcement for lacking a mask. The circumstances around that may be contested, but the reality is simple. If California really wants to make sure that this mask requirement is adhered to, provide the masks to public places of accommodation so that they can distribute them on receipt of persons upon those orders. That would help considerably resolve that particular issue to the degree to which the masks are available. And maybe, Caitlin, one last question.
Will the courts have enough time to rule on these issues, or will they become moot because the emergencies will be over?
Oh, nice. Now, here's my observation on that, and this is a pure jurisdiction-related concern. Listen, for non-lawyers, what and how we actually see the opportunity for things that may have potential to become moot, because basically the issue's over, COVID-19 passes by, or a specific order is dispensed with, like in Texas with the reproductive rights situation. The order may be finalized fairly soon, but it's capable of repetition, as is COVID. Second wave related concerns, I think consistently will have courts reviewing and assessing these issues, even if the immediate threat to a particular right is dispensed with. That, from a jurisdictional perspective, seems to be at the source of a lot of what courts are understanding now. We need resolution on this now because COVID-19, until it's completely in the rearview mirror, has to be assessed as a recurring phenomenon. Great point. Thank you so much, and I'll turn it back over to you, Kayleen and Charles.
Thanks, James, and thank you, Kayleen, for moderating today. Just a few final notes to all of our attendees. If you submitted a question that did not get addressed during our Q&A session, don't worry. We'll be reaching out to you to ensure your questions get answered. And also, all attendees will be receiving a link to our network webinar survey. And it takes just 1 minute to fill out and provides us with some really great insights, especially in regards to what topics you would be interested in for future webinars. You'll also be receiving an email from ASL and me with information on how to apply for CLE credits for this event. Join us next Thursday for a webinar on COVID-19 and public health decision-making, where presenters will provide attendees with a legal and ethical framework for executive decision-making, covering mandatory and discretionary actions and the exercise of professional judgment in responding to COVID-19. Learn more about that webinar and view the network's collection of resources on the pandemic at networkforphl.org/COVID-19. That concludes today's webinar. Thank you all for attending and have a great rest of your day.